Hi, everyone. Mimi Rocah here for Talking Feds. And I want to talk to you today about something that you may or may not be following in the headlines. And that is Trump's, let's call it sanctions, punishments, attacks on the legal industry, specifically law firms, but I'm going to broaden it out a little bit. And I want to talk to you really, I'm not going to go into too much detail, give you a broad overview and tell you a little bit about why this is important and talk mainly about the response to what Trump is doing. So very generally speaking, Trump has issued some executive orders against particular law firms, or it started with particular law firms. The first one was against a law firm called Covington and Burling because of its representation of previous special counsel Jack Smith. The second one was against a law firm called Perkins Coie because of, amongst other things, its previous representation of Hillary Clinton and the Democratic Party generally back in 2016 and following that. And the third specific one, was against a law firm called Paul Weiss, and that was said to be because of the prior relationship with someone named Mark Pomerantz, who was a partner there for a long time and then left to go to the DA's office and worked on one of the criminal cases against Trump. The final order, executive order, or I should say the most recent one, was one, I think just last Friday, which was much broader, and it covered basically any lawyers. It singled out immigration lawyers, but it covered any lawyers who bring, quote, frivolous lawsuits and claims against the government in court, which is very broad. Okay, I'm not going to go into detail about these orders. They differ in some specifics that may or may not make a difference in terms of court challenges and the specifics. But broadly speaking, as I've mentioned, they all are brought for the reason that Trump and his allies and his administration do not like either cases that the law firm worked on or clients that the law firm had. Okay, so that's one of the most general but unifying things about all of these, right? Even the last one, which is the most broad, it talks about the immigration bar, it talks about big law pro bono. It's less specific in who it targets, but again, it's getting at the issue of you're suing the government. Well, we're going to look at you more closely and target you and penalize you more than other people who bring other kinds of lawsuits. So why does this matter? Why should the average person care about what Donald Trump does to big law or even immigration lawyers or pro bono lawyers? It matters because the word we always use, this is completely unprecedented and dangerous. Why? Because the regulation of lawyers, what clients they take, what arguments they make. Of course, lawyers shouldn't make frivolous arguments. You know what? There's a federal rule for that. And the regulation of the kind of arguments, the kind of clients they take, the kind of pro bono work they do, that is all already regulated very much by both the states, individual states, right? This is the administration that supposedly wants to leave things to the states. Well, states do a very good job of regulating this because each state also has a bar and ethics rules specific to the state. There are federal ones for federal court as well. But this is already a very regulated area and a very complicated area. These executive orders are written in a way that is so broad as to be maybe meaningless in practicality, but dangerous in their goals. Again, because they're targeting firms for their clients, for their cases. What is to stop them? I mean, we don't even need to say here, though, what is to stop them from targeting someone just because they don't like them, because that's really what they did, for example, with Covington and Burling, because they represented Jack Smith or are representing Jack Smith. Now, I want to talk about, there are broad constitutional issues here about the right to counsel under the Sixth Amendment and each state's right to counsel and how clients can choose their law firms. There is due process in terms of individual lawyers they're threatening to sanction because the administration deems something frivolous. But there's actually a process in court for determining that. So there are broad constitutional and complicated legal issues here. But I think what I hope people take away from this who aren't lawyers is that you have the administration targeting private businesses, people who have law licenses, which they had to, take tests and have to pass ethics rules and bars and exams and all sorts of requirements regularly in order to stay a lawyer. And there are rules that they operate under. And here you have the federal government just jumping in, the administration, and saying, we're going to regulate this how we say so according to our standards. That is just so broad and so dangerous. I think anyone, even if you're not a lawyer, can understand that. Now, I want to just take a minute to talk about the response to these administrative orders, okay? You've had a variety of responses to the individual orders. Covington and Burling essentially said, we're just going to keep doing what we're doing. We're still representing Jack Smith. So they put out a statement saying, you can't do this, but they didn't take a legal action. But they certainly said, we think this is wrong and we're going to keep doing what we're doing. Okay, that's their choice. Perkins Coie filed a lawsuit in court, and a judge already said, yeah, this order is illegal. Or on the merits, I think it's likely to prevail. You're likely to prevail that it's illegal. And so I'm going to issue a preliminary injunction, which is not surprising that she did that, given everything I just said, but also a very big moment. And then Paul Weiss, the last firm to be individually targeted, actually struck a deal, so to speak, with Trump, where there was an individual meeting between the head of the firm and Trump, who later put out a statement which was somewhat inconsistent with the actual agreement. But in broad strokes, the agreement said that Paul Weiss was going to commit funds to pro bono cases that the two parties, i.e., the Trump administration and Paul Weiss, could agree on. And this is a firm, Paul Weiss, that already does a huge amount of pro bono work, and the amount of money that they agreed to commit under this agreement is actually a reasonably small portion of what they already do. There were some other parts of the agreement, but the important part is they reached a, quote, agreement, and then Trump lifted the order against Paul Weiss. Now, this has caused huge emotional outrage and feelings from lawyers and non-lawyers, but I've certainly seen it from the legal community. And I want to talk about why, and then I want to end with just kind of broadening this out a little bit. I think the reason this has prompted such outrage, okay, there's a professor from NYU Law School, very distinguished professor, Stephen Gillers, one of the leading ethics professors there is in the country, law professors. And he actually wrote an article saying, yeah, Paul Weiss struck a deal, but I don't think it was capitulation. And here's why. And I recommend you read Stephen Gillers' article. And, there is different ways of looking at what Paul Weiss did, and people are going to have their opinions about it. Was it the right thing? Should they have fought it in court? Was it capitulation? Or was it just a deal that, law firms tell their clients to take all the time? I'm not here to give you sort of what my view of that agreement is. What I'm here to say, what I hope you take away from this, one of the other things, is about the fact that I don't think Paul Weiss should have been in this position to begin with. In other words, I don't think any of these law firms, right? And I feel like we're losing sight of that. This happens so often with actions taken by Donald Trump and his administration. It was true the first time around, and it's true in this administration even more. What happens is they take unprecedented actions that no one imagined they would actually do, even though probably had a pretty good heads up about it. And then there's this frantic scramble to respond, whether it's the Democratic Party, law firms, the press, nonprofit organizations, whoever the target of the day is. And then there's some response, and everybody else piles on and criticizes or supports the response. And so what happens is the wrong action, the action that has already been found illegal by a judge, the action that is so clearly beyond the bounds of what a president should be doing, regulating individual lawyers and law firms, gets lost. And we stop talking about that. And we're talking about the reaction. Now, I'm not saying people shouldn't criticize Paul Weiss or any other firm or any other individual whose response they don't like. That is what we do here. But we are losing sight of the original conduct here. And that is exactly what happens so repeatedly over the past, 10 years, basically. And part of why Trump's tactics, I think, are so effective. So it's okay to criticize what Paul Weiss is doing, but let's not forget what they were reacting to, which was a totally illegal, unethical, beyond the bounds order by a president. And that is what we actually need to keep our focus on. And I'll give one example. And it's problematic that there was not a unified response by lawyers, by big law, when the first one came down against Covington, because that was the time for collective action. It's not too late now. But I think if that had happened, if all the law firms then had stood together and said, you can't do this. This is way beyond the bounds of what you're going to do, and we're going to be united, and we're going to represent each other, then I think it would have been less tempting, let's say, for Paul Weiss to strike a deal if that's something that people didn't like. And, I'm also talking about in-house counsels at corporations. They're the clients who are affected by this. Where are they? They should be speaking out. I'm not saying no one is. There are. So this is not a broad condemnation, but we need more, and we need it collective. And I want to give one example where that happened. And I think it was somewhat effective. And that is in the role of the Department of Justice. As you know, we had resignations by, I think it was 8 different prosecutors in the Southern District of New York and the Department of Justice in response to an illegal order about a month ago, I think it was, what I consider an illegal order from Maine Justice to drop a prosecution against Mayor Eric Adams for illegitimate reasons. And you saw there this sort of cascading movement of courage where the acting U.S. attorney and the SDNY resigned, other prosecutors in the SDNY, prosecutors at Public Integrity. Then you saw this joint statement from well over 1,000 former DOJ alums coming out and saying, yes, we support you. That was the right thing. And this isn't political. I mean, these are people from who served in Republican administrations, Democratic administrations. The people who did those resignations were members of the Federalist Society and clerked for some of the most conservative Supreme Court. So this is about the abuse of the law system. It's all tied together. There's a through line here, whether it's DOJ, private law, and the response needs to be as unified as is the attacks. So I'm going to leave it at that. I hope this was helpful in getting you to kind of pull back and at least think about this in a more broad way, and hopefully get us to refocus a little bit on what the real problem is here. Yes, we can criticize the actions of individual responses, but we got to keep our eye on the ball, which is these illegal, unethical, out of bounds orders coming out of the administration. Thanks, everyone.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.